May I see it in order for that session?
Thank you, Sheriff. All right, is anything anyone else wants to say on in charge 13 CRS 67, which is entitled Assault on a Law Enforcement Officer Inflicting Serious Injury? Anything else you want to say about the lesser and included offenses?
Not for the defense, in addition to what we've already said.
Thank you.
I was going to say nothing in addition to the same.
These are the questions I've been entertaining. Is there a pardon me for using the word serious, but is there a serious dispute that the injury was a serious injury? And then that, and if not, I'm not sure what, that I would give something that didn't include the serious injury in it as a part. Then there's not an issue on that charge about, well, there is an issue of whether it's an assault or not an assault. That's kind of what the argument is about. And the next question is there a serious dispute in the evidence that Mr. Stewart was a law enforcement officer on this occasion? I don't, the evidence that I heard was there was an unmarked vehicle, but it had flickering or flashing lights and a siren, and Mr. Riley pulled over as a result of whatever that was. That the evidence that I heard that there were some handcuffs that were observed by Mr. Riley and a badge observed by Mr. Riley, and eventually his weapon. Of course, you know, lots of folks can have weapons. But the question arises, is there a serious dispute as to whether it was a law enforcement officer? I'm looking at things that the jury could say, there's a question as to this. You know, some reasonable question as to this. I'm not trying to supplant what the jury decides, but I'm just sort of going by the elements here. It just strikes me that there didn't seem to be a dispute on the injury as to whether that was a serious injury. I don't know. Maybe I don't want to concede that or whatever, which is done for that would be for the defense. But as far as the evidence presented, there was evidence of a gunshot wound received that shattered the femur and ended up with pain, some suffering, and a titanium rod or something inserted in the leg, which is still there. In actuality, could a jury reasonably dispute that that's a serious injury? You know. What I'm getting around to is whether there's anything but assault on a law enforcement officer inflicting serious injury or not guilty. That's my question. Whether it amounted to an assault is certainly sort of the crux of the matters at issue here, but whether it's a law enforcement officer or a serious injury, that's what my questions are. And I'm even considering that as to whether to consider what at least the pattern jury instructions say is a lesser included offense, that is physical injury. That means something other than cuts, bruises, and things like that, other than a serious injury. The injury we're talking about is the shot to the leg, not the beating around the head. That has other implications and emphasis in the jury argument as to credibility and things like that, but among other things. But the injury we're talking about is a shot that shattered a femur. And the question is, how did that shot occur? Not so much whether it was a police officer or whether it was a serious injury. And that's what I spent my lunch doing. So let me hear from the state, and then I'll ask the defense to kind of respond to what I sort of said out loud.
The state agrees with the court. The facts do support that instruction.
Or the evidence.
Or the evidence.
Not the facts, but the evidence. Or from the defense.
I understand what Your Honor said, and that all sounds reasonable in terms of what a jury could find as to what was going on. Not necessarily from the arguments, but something they come up with themselves about what really was happening there. I think I'm duty bound to ask for those. I don't have any argument countering what you said. I mean, so I guess since I don't, I'll sit down. I understand what you're saying. You're still asking for the charges we asked for before, but I understand what you're saying. And I'll just sit.
All right. Then I believe as to that charge in number 67, it's guilty to assault inflicting serious injury on a law enforcement officer or not guilty. We'll get to the other matter. I'm just looking at the substantive ones to start off with. In case 13 CRS 68, the charge is robbery with a dangerous weapon. So that's the count that's left. So what I'll hear you on is as to whether it's that or not guilty, or that common law robbery and not guilty. Mr. Charles, you're up.
Yes, Your Honor. I would argue the common law robbery is the lesser included based on the unique facts in this case, as well as larceny from the person, which I believe we had a case citation, State versus Young, 283, Southeastern 2nd, 8/12/1981, and I have not shepherdized it, but it appears that larceny from the person is a lesser included as well. So I'll try to, as the prosecution is speaking, I'll sit down now and look to see if I can shepherdize that.
Yes, sir.
But those would be the lesser included in the circumstances here would be appropriate considering the sort of unique facts in this case.
All right, Steve?
Your Honor, the state has no objection to the jury instructions, including common law robbery as a lesser included of the robbery with a dangerous weapon. But because the evidence in this case does involve an assault between Investigator Stewart and Mr. Riley, the state would argue that the larceny from the person would not be appropriate given the evidence that has come out in court, and we'd ask only for the common law robbery as a lesser included.
Thank you. What's that citation again there, Mr. Charles?
It's 283 Southeastern 2nd, 812. It's 1981. I have the NC App site if that would be helpful.
That would be helpful.
It's 54 NC App 366. And I pulled it up. The Shepherd says no negative subsequent appellate history. I don't have a copy of it because Mr. Donovan showed me on his smartphone before lunch. So.
All right.
Read the first sentence of that might be illustrative of what the argument is here. Unless Your Honor has it.
I don't have it yet. I'm looking at something else and I...
Okay.
All right, anything else anyone wants to say?
Nothing for the state, Your Honor.
Thank you. Mr. Charles?
Actually, I saw something in the assault, but since we're on robbery, if I could go back, there was something I noticed about these indictments that I'd like to just put on the record after we get done with the robbery instruction.
All right, let's finish the robbery
Yes.
instruction. Anything you want to add to that?
No, the case I cited, as Your Honor saw, the defendant was indicted for common law robbery, and that was insufficient, and the judge submitted larceny from the person, and the accused was convicted. And on appeal, he said, well, you shouldn't have submitted that, it wasn't a lesser included. And the way I read the opinion, it said, yes, it was, you lose. Judge Beckton dissented. And so if it's a lesser included common law robbery, in this case, where it's very unusual facts, I think the larceny from the person would have to be instructed upon. That would be my argument.
All right, thank you. I am going to allow larceny from the person as a lesser included. What was it that you wanted to add back to the previous case?
Yes, Your Honor.
The previous, in 13 CRS 67?
This would be 67 and 70, the indictment for assault with a firearm on a law enforcement officer and assault on a law enforcement officer inflicting serious injury. Looking at these indictments again, it seems to me there's a double jeopardy issue, and the state would have to elect between them. And the citation, the case citation would be State versus Hunt, a case that I had in the Court of Appeals and went up twice to the North Carolina Supreme Court. But the operative ruling was in that case, which was factually, and the charges were very different. There was crime against nature and sex offense. And normally that wouldn't be the same crime, but the way the indictment read in State versus Hunt was it was the same crime, and that's what the Court of Appeals held, and the Supreme Court didn't deal with the issue, so that became the law. And this is very similar in that if you look at the indictment, I mean, one talks about the rod in the leg, but both of them involve a weapon and involve an injury, and involve the same weapon and the same injury. So for double jeopardy purposes, I would argue that this, even though they cite a different statute, I would ask that they elect between these two charges. And my second position on that, if Your Honor doesn't ask them to do that, and certainly if there's a conviction of one would have to be set aside because for double jeopardy purposes, both under the U.S. Constitution through the 14th Amendment and then Article 1 of the North Carolina Constitution, my argument is it's for double jeopardy purposes the same crime. It's worded a little bit differently, but under the authority of State v. Hunt, and I'll try to find that if Your Honor would like to see that case. It's very complicated, and as I said, it went up to the North Carolina Supreme Court twice, and the ultimate ruling in the Supreme Court didn't deal with the dissent that became the double jeopardy issue. So I'm happy to get that slide for you. I'll find it while the prosecution is discussing this.
Thank you. Yeah, that won't be necessary. I'm going to overrule your or deny your request there. I'm assuming it's that one of those ought to be dismissed. And I'm going to deny that request. So just make that notation. The next matter is 13 CRS 69, which is the charge of assault with a firearm on a law enforcement officer, to wit, pointing a gun at an officer. Mr. Charles.
I don't have any argument in response to this.
So what I'm hearing is guilty or not guilty.
Yes, Your Honor.
All right, thank you. For the state.
The state seeks no lesser included, so we'd ask for guilty or not guilty.
Thank you. That's what we'll do on that one. In comes 13 CRS 70, subject to the request that's been previously made and denied. That's assault with a firearm on a law enforcement officer by shooting the officer. Mr. Charles, you, other than guilty or not guilty, do you have any other requests on the substantive?
I do not.
All right, thank you. For the state.
Your Honor, guilty or not guilty?
That's what we'll do on that one. Reckless driving, guilty or not guilty.
Yes, Your Honor.
Any other matters to address on the, what essentially the potential verdicts would be? That's what we're talking about here.
Nothing in the state, Your Honor.
No, Your Honor.
Thank you. Now, we've got additionally the definition of intent, the definition of assault. There are a couple of different definitions of assault. One's battery and one's offensive touching sort of thing. I'll look at those. Other ones that I was looking at, if you'll get your pens and pencils out, and we'll fill in. Pattern jury 101.05, which is function of the jury. 101.10, burden of proof and reasonable doubt. 101.15, credibility of witnesses. 101.20, weight of the evidence. 104.05, circumstantial evidence. 104.10, motive. 104.35, flight. 104.50, photographs, diagrams as illustrative evidence. 101.30, effect of defendant's decision not to testify. 270.80. Charge of assault inflicting serious injury on a law enforcement officer is 208.94. Robbery with a firearm is 217.20. These are the pattern rulings, so that we've got some common reference points. I know we've got some requests here that I need to address. Assault with a firearm. No, that was dismissed. Assault with a firearm on a law enforcement officer is 208.95. Concluding instructions, 101.35. Concluding instructions include advising the jury that their individual recollections are to be relied on, not ours, and consider all the evidence, impartiality of the judge, and how unanimous verdict works, and about selecting a full person. Those, and then intent. Definition of assault and pattern jury instructions is that 120.20, and definition of intent is 120.10. As to 13 CRS 67, assault on a law enforcement officer inflicting serious injury, there's a case that addresses sort of that issue. It recognizes that in the title to the statute it refers to serious injury, In the body, it refers to serious bodily injury. The jury instructions sort of, refers to the serious bodily injury, that being injury that creates or causes a substantial risk of death, serious permanent disfigurement, coma, a permanent or protracted condition that causes extreme pain, permanent or protracted loss or impairment of the function of any bodily member or organ, long hospitalization. The one that seems most apropos is a permanent or protracted condition. Whether it causes pain or caused pain. Is something that explained to the jury, can be explained in jury argument, that causes pain doesn't mean now. It could mean then that it causes that. All right, Mr. Charnes.
Yes, Your Honor. And Your Honor is referring to the indictment 13 CRS 67, the assault on a law enforcement officer inflicting serious injury.
Yes, sir.
If you take a look at the body of the indictment does not charge serious bodily injury. Therefore, to instruct them would be a fatal variance. It's not in the indictment, and so this indictment actually doesn't charge the 14-34.7. It charges something lesser. And just to place on the record, I would object to instructing the jury as to something that my client hasn't been indicted on, has been indicted on some lesser charge. So to instruct them otherwise, I guess in a sense the indictment's defective as to charging 14-32.7 because it alleges a serious injury, not serious bodily injury, which is something higher. So I would actually object to presenting this to the jury at all.
Thank you, Ms. Evans.
Your Honor, the statutes also allow for the state to amend any charge before, during, or even after a case has gone through, so to bring it into alignment with the facts in the case, or in alignment with the as long as with the statute, as long as it doesn't materially alter. And as Your Honor has stated, that this 14.37 includes assault inflicting serious injury on a law enforcement officer, probation officer, or a person employed as a state or local detention facility, and basically that is the heading of that. And the body of this does say assault. A is inflict serious bodily injury on the officer. It says anyone who assaults a person who, I'll read it, A, unless covered by some other provision, as a Class F felony if a person assaults a law enforcement officer, probation officer, or parole officer while the officer is discharging or attempting to discharge his or her official duties and inflict serious bodily injury on the officer. B, anyone who assaults the person who is employed as a detention facility officer is covered by B, and unless under some provision of the law pertaining to a greater punishment, it's a Class I if the assaults with the law enforcement officer or parole officer inflicts physical injury, and that's 1 or 2. So there is a conflict in the body of the law itself, but in order to put everybody on notice, this has been a statute that's in the books. He knows about the statute, he's read the statute, and the statute and the language of the indictment are similar. And so therefore, I'd argue, number one, that this is a correct indictment, and number two, that if it doesn't, then the state can amend that to serious bodily injury or serious injury as the court decides. But due to the language in the statute and the language in everybody's been put on notice. So either A, you can concede that this is a proper charging document, or B, that the state would move to amend that to include serious bodily injury, as it does not materially alter any of the circumstances that he's put on and presented, and he has notice of all of the information. It would not change the way that he dealt with his case in any way.
Thank you. Mr. Charles, you have the last word on that.
Yes, Your Honor. It's a fatal defect as to 14-34.7. It's an indictment. We're 2.5 years. This is 1/7/2013. And it doesn't charge the crime it cites. It can't be amended because it's a substantial change. So I object. I object to them amending the indictment almost 3 years, more than 2.5 years after the incident and after this indictment. And it does change what's alleged. So I would ask that this not be presented to the jury as a potential verdict, and note for the record that we pointed this out at this time, not at some later time. So that would be my argument. And I will sit down.
Thank you. What I see in the statute is that the heading says assault inflicting serious injury. The body in paragraph A says serious bodily injury, the body of the statute. Then in subsection C, it talks about sort of what appears to be a lesser included, but they call it physical injury, and then defines physical injury in the final paragraph as not being serious injury. Then our reading over the case of State versus Crawford from 2005, it's 167 NC Act 777, in which they address the fact that the heading says one thing, the body says another thing. In that particular case, the argument was made that it should just be a misdemeanor because there's an assault inflicting serious injury that was a misdemeanor. And this is Judge Wynn said, well, that's a pretty good argument, except Supreme Court told us that instead of following the time-proven principle of leniency on interpretation, we're going to follow the manifest intention of the General Assembly test, and noted that serious injury and serious bodily injury, in North Carolina law are kind of like two different things. There's a whole set of statutes on that, but that clearly, in adherence to the directions of the North Carolina Supreme Court, that it was intended to be a felony. I guess what I'm getting around to is the two injuries that are referred to in the statute are the serious injury or serious bodily injury and physical injury. That the indictment appears to refer to the serious versus the physical injury aspect of the statute, and that amending it to say serious bodily injury would not change the nature of the offense that was charged or the notice to the defendant as to the particular charge being defended, and consequently the court is going to allow the amendment to say serious bodily injury versus serious injury. And I'm going to note defense's objection to that. But the court, in given instructions, will define what serious bodily injury is. For the benefit of the jury. All right, I think everybody's had an opportunity to review the proposed instructions from submitted on behalf of Mr. Riley. Before we get to those, we've got a rather large issue to address, and that's the issue of self-defense. So, Mr. Charnes, let me hear you first on whether the jury is to be instructed, and consequently whether jury arguments can include reference to self-defense, and then get a stated opportunity, and then you'll get the last say so on that. Mr. Charnes.
Thank you, Your Honor. And I am going to be reading from page 85 and 86 of the motion to suppress transcript of the motion to suppress hearing on April 20th, 2015 in this very courtroom. In question, and what you told Corporal McMasters is you told in the car, quote, I told Carlos Riley, get back, I'm going to shoot you, I'm going to shoot you. That's what you told him on the tape, correct? Answer, yes. Question, get back, I'm going to shoot you, yes. And you said it twice, yes. So, and as Your Honor may recall, we made a defense exhibit for identification because the testimony on direct of Officer Stewart was get back or I'll shoot you. And there's a very big difference between get back, I'm going to shoot you, I'm going to shoot you, and then giving it the other way. And the state came back with a part of the transcript on direct that they had some language more of liking to themselves. But at this point on self-defense, the evidence is taken in the light most favorable to us, to the defense, and you have a situation where this officer has testified and given various statements, everything from I'm in the passenger seat, on my back, and this gentleman, my client, Mr. Riley, is on top of him, saying get back, not get off. another version, and another one of the statements is Mr. Riley is actually outside the car, and the officer is saying, "Get back, I'm going to shoot you, I'm going to shoot you," which makes more
Was
sense.
that in evidence in this trial?
I asked the question on cross, didn't you say on another version, another one of your statements, that Mr. Riley was out of the car? And my recollection of what he said was that wasn't another statement. Also, the question of, well, let's stick to that. So we have, is he out of the car? Also, as Your Honor heard, actually, in one of the search warrants, I mean, just tying some of this together, they put in as probable cause that Mr. Stewart, Officer Stewart, was chasing my client. There was also another statement, my client was shot once. There were 3 shots. And all of that's kind of hazy, but it's all thrown in there. So this is all about squealing tires. We have an officer in the light most favorable to us. He's up to no good. He violates the policies of his department. He violates state law about the SBI 122 form, and is still to this day in violation of that state law and the general order. He's operating off the books and threatens to shoot a man that, from the light most favorable to us, has squealed his tires and presented a driver's license and a registration and has been patted down. And that car's still on. So this is a very freaky, bizarre situation. But when the officer says those words, "Get back, I'm going to shoot you, I'm going to shoot you," to not give self-defense here is reversible error, plain and simple. So I'm going to sit down because this case is so clear from the prosecution evidence, no reason for us to do anything. They don't even have a doctor. They didn't put a doctor up there. They tried to get medical records in through someone who collects the records up. So this is a case where the gunshot residue, they didn't want the form coming in. They didn't put the expert up.
I'm on self-defense.
Yes, Your Honor, this all goes towards it. Is the weakness of their case in proving something other than this officer drew on my client, and the officer testified to a number of scenarios, some of which are actually impossible for the human body to do those things. So yes, self-defense, if it's not instructed, I've requested it. We've requested special instruction. By their evidence, by their testimony, sworn testimony in this courtroom, not only during this trial, but previously, "Get back, I'm going to shoot you, I'm going to shoot you," justifies the self-defense instruction without any more being said. We can add all the other things in this trial that would justify it, but that itself justifies it. And since Your Honor said you'd give me a chance to speak, I'm going to sit down because I think this does it.
Thank you for the state.
Your Honor, the evidence that has come out in this hearing, in this trial, shows testimony by Investigator Stewart that before the traffic stop was complete, the defendant drove off. He got into his car and drove off. When the investigator tried to stop him from doing so, he kept driving, thus endangering the officer. Your Honor, that would make the defendant the initial aggressor in this entire transaction, and that should, in the state's opinion, put this case in a posture such that the defendant is not entitled to an instruction of self-defense.
Is that not a matter for the jury to decide whether the defendant was the aggressor or not the aggressor? Or are you saying that as a matter of law is all the evidence we have, therefore no need to put it to a jury?
Well, Your Honor, whether or not the the defendant is the first aggressor, in theory could be an issue for the jury, but there has to be evidence that the defendant had reason to believe that he was in danger in order for us to have a self-defense instruction for the jury to decide. And in this instance, every decision made by the defendant caused this situation to escalate. This started as a traffic stop. This was not a fight between two private citizens. This was a traffic stop whereby the defendant did not follow the officer's directions. And his failure to follow the officer's directions, he willfully engaged in a fight with the officer of his own volition. So for those reasons, we ask that the court not allow the self-defense instruction.
Mr. Charles?
Yes, Your Honor. You may recall the EMS report showed no injuries to the officer's face. His testimony was he was beaten in the face for quite some time. There's no evidence of that. The state didn't put in pictures of the officer's face because they show no injuries. The evidence they did put in shows no injuries. This is exactly for the jury, as Your Honor asked. It is for the jury. The question of excessive force, whether they believe the officer, and again, that statement echoing, get back, I'm going to shoot you, I'm going to shoot you, along with the other evidence or lack of evidence in this case, that my client, if excessive force was used by the officer, which we contend in that statement, that threat, that is a threat to shoot, and he could take it as a threat to kill, that in this case, what we know, it's not a situation where it would be different if he had taken the firearm and stepped back and shot the officer. This is a case where the officer admits his hand was on his own firearm when it discharged. And it's up to the jury to believe, did the officer have his finger on the trigger or not? My client has no burns on his hand, Your Honor. All these inconsistencies and holes in the evidence, what the evidence in the light most favorable to us, a jury can find my client used reasonable means to defend himself, to stop from being shot or killed by a simple gesture that was not excessive. And again, it's in the light most favorable to us. It would be reversible error not to give a self-defense instruction in this case. This case is very, very different than any other case I've seen or reviewed in the appellate record. So we would ask for that self-defense instruction. Thank you.
Thank you.
Your Honor, if I could point out, someone at our table would like a comfort break here.
Go right ahead, Barry.
We'll be in recess for about 10 minutes.
Court recess 10 minutes.